What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. I got a bunch of cases for you this week, so let's get right to it. First case is a stalking injunction case, which is similar to a domestic violence case in that it's, it involves stalking, but the difference is that domestic violence has to be between household members. So what this case was, a ex-girlfriend against an ex-boyfriend. Apparently the ex-girlfriend got arrested at some point, and she was on release, and she was supposed to have no contact with her ex-boyfriend, but the ex-boyfriend was the one that kept contacting her, and apparently she was pregnant, I guess, with his child, and so she filed a petition for injunction against stalking, and the trial court basically denied it and said it was legally insufficient, that what she alleged in the petition not enough. Appellate court reversed and said yes, it would have been enough. Apparently the ex-boyfriend continued to contact her, was sort of baiting her into violating her no contact order in her own criminal case, and basically so it was harassment. It served no legitimate purpose, would cause substantial emotional distress. He also apparently was going to show up at the hospital when she was going to give birth, so that was sufficient. Interesting, and also the thing was the trial court basically just entered a blanket order denying, saying that it was legally insufficient without saying why. And so if you're going to deny a petition for injunction against stalking, you got to specifically say why. The other thing that was interesting is that the court stated that this petitioner may have a cause of action for domestic violence injunction and may have a cause of action in paternity, but for some reason didn't feel that there was enough for a stalking injunction. Anyway, that got dismissed. That got reversed on appeal. There was sufficient allegations. Next case is this famous Terry Schiavo case from a long time ago. Well, apparently somebody moved to open up the records, make them not confidential anymore. This was like a third-party group that was trying to unseal the records, and it got denied, even though the third-party group may have had the best intentions in mind. It wasn't legally sufficient to unseal the records, so that got denied. That was a famous case a long time ago with the person who she was in like a incapacitated state, and it was a question of whether to pull the plug essentially, and so they wanted to see what happened in the case with the confidential records, but those remain confidential in this guardianship proceedings. The next case was interesting. It's a civil case, but it involved dismissal of striking of pleadings, striking of defendants' pleadings with prejudice, essentially for discovery violations. And the fact that normally I always thought that if you're going to do that, you need to have one of those Cozell hearings, Cozell versus Cozell. It's like an evidentiary hearing. You have to go through the factors. But apparently in a case where it's not the attorney's fault at all, where it's like no attorney fault for violating the discovery order, essentially this was where somebody failed to show up for a deposition multiple times. So in that scenario, you don't have to do the Cozell factors before getting a dismissal, striking the pleadings of the defendant. So you don't even have to go through all that. You can get a strike the pleadings. If the defendant fails to appear for deposition multiple times, strike the pleadings. You get automatic summary judgment, essentially. This is what they got because the pleadings are stricken. And you don't even need to go have that evidentiary hearing on the Cozell factors. The next case is a dissolution of marriage case, relocation. And this has to do with relocation by agreement. So apparently the parties here, they were in a different country. I think it was Colombia or something like that. They entered into an agreement for relocation, essentially, that would allow the mother to relocate back to, I believe it was Colombia. And the problem, though, was the relocation agreement that they had signed, and that was entered into evidence apparently. It did not contain a specific time-sharing schedule, and that's required. If you're going to relocate by agreement, you need to have a specific time-sharing schedule that sets forth, the access for the non-relocating parent. So they did not have that. It was more of like a kind of a liberal visitation, we'll revisit it kind of a thing, but that's legally insufficient. So even if you get something that says, by agreement, we allow, wife to relocate or former wife to relocate, that's not enough unless you have an actual relocation time-sharing agreement, relocation parenting plan, access schedule. So that got reversed. Last case, this is like a MSA case, essentially, equal distribution of a pension plan, firefighter pension plan. This was a concurring opinion, but what I thought was super interesting is that they allowed the former wife to get an income deduction order against the pension when the pension pays out. So essentially, they got divorced a long time ago. MSA says that wife gets 40% of any pension payments that the former husband receives. He continues working after divorce, eventually retires, and now the wife wants an income deduction order against his retirement payments. I didn't know you could get an income deduction order for something that wasn't child support, alimony, or attorney's fees related to those. But apparently, if you could get it as long as you don't object. So the other side didn't object apparently during the hearing. And so it seems like there's going to be an income deduction order for the payments of this pension, which was very interesting to me. So make sure if you have one of these cases and you don't want that, make sure you object, and might as well ask for it, I guess. if you're the one that wants the payments, might as well ask for an income deduction order and let the other side object, because if they don't object, apparently you might be able to get yourself an income deduction order for pension payments. All right, guys, that's it for this week. Take care.